Hi, my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law. Please subscribe to our channel. We were asked recently, how does a father establish paternity? So let's understand the scenario. A child is born. It's a non-marital union. So the father suspects that that's his son or daughter. How does he establish this? Well, really, what has to be done, from a scientific standpoint, there has to be a DNA analysis to determine the paternity. It's great if everybody cooperates in the process. However, if mom won't cooperate in the process and dad thinks that that's his kid, then there has to be a lawsuit filed. You have to reach out to your attorney, and your attorney will file what's commonly known as a DP case, a petition to determine paternity. The court will conduct a hearing, and if the court feels that there's a reasonable belief that this is the father, we got to establish this, the court will order DNA testing at a recognized court-approved lab, and then the child will have to be brought in and swabbed, and the father and all that, and then they will determine to a probability whether or not this is the father. Most of the time, when those tests come back, they are 99.99% probability ruling the father in or out. If the father's ruled into paternity, i.e. that means from a biological standpoint he is certainly the father, in that scenario then of course there are certain rights that will attach. There are benefits and burdens that will follow, and amongst them will be, for example, custody rights, parenting time rights, child support rights. All of these things will flow from that, but first the court has to make the determination regarding the actual paternity. If you have any questions about that or you're in that situation, reach out. Of course, we'll be glad to help you out.